A Utah death sentence is closer to being carried out. Hello, I'm Richard Pyatt, and this is Legally Speaking. Taberon Honie has been on Utah's death row for 25 years. In June 2024, he made one last plea for clemency with the Board of Pardons and Parole, but other than that, his death warrant has been signed, and his execution is set for August 8th. In 1999, Honie was convicted of the extremely violent murder of his girlfriend's mother, Claudia Benn, in Cedar City. Benn was viciously and repeatedly stabbed to the point of mutilation. Honie was arrested at the scene, confessing, quote, "I stabbed her, I killed her with a knife." Benn's 3 granddaughters were present during the murder. All had blood on them. A 4-year-old was also sexually assaulted. Graphic details set the stage for this Legally Speaking edition. Now, after exhausting all of his appeals and collateral challenges, Honie is asking his sentence be commuted. Will the execution go ahead as scheduled in August? Perspective on this case now from Daniel Boyer, Deputy Solicitor General in the AG's Criminal Appeals Division. Thanks for joining me today, Daniel.
It's nice to be here.
And I know this case is at its end stages, but it is still working. Can you talk about the response our office supplied in response to Honie's last-minute petition for commutation?
Yes, absolutely. We filed our response to his commutation petition just last week on Friday, June 21st. In that response, we argued that Honie was not entitled to commutation. The Board of Pardons only has the authority to commute Honie's sentence of death to life without parole. We argued that they should not exercise that discretion. We argued that Honie's petition had not shown that there was a substantial reason for granting commutation and undoing his death sentence.
Is it typical for a person in Honie's position to make this last-minute appeal? Is this part of the process, or does he have some kind of special circumstance that he's trying to exercise to get him out of actually facing the lethal injection that he chose 25 years ago?
Yeah, this is nothing out of the ordinary. The death row inmates have an automatic right to petition the board for commutation after the sentencing court signs the execution warrant. And that's what Honie did here after the June 10th warrant hearing, when the judge issued the warrant of execution to take place on August 8th. Honie quickly filed a petition for commutation with the Board of Pardons.
So we mentioned that he selected lethal injection. There were some questions about the effectiveness and the humanity of lethal injection, whether it caused undue pain and suffering. Have those issues been resolved? Will he, in fact, face lethal injection, or is that something that is a separate issue potentially for him?
Well, the lethal injection issue is currently in litigation. Interestingly, Honie did not select lethal injection. He was required to make a selection at his 1999 sentencing. And the statute said that if he didn't make an election, then the default was lethal injection. And that's what happened. He didn't make an election in 99, and so the statute made the decision for him, essentially. And he, again, was given an opportunity at the June 10th hearing this year to make an election. He declined to do so, saying that he didn't have adequate information about the protocol that UDC, the Department of Corrections, uses when administering the lethal injection punishment.
Okay. So does the petition for commutation change the August execution date, or is when this is resolved through pardons and parole, will that August date stand then, or does that stand to potentially change?
Currently, it's not going to change. The Board of Pardons does have authority to temporarily stay the execution date or move it forward a bit if it believes more time is needed to decide the commutation question. We don't know. We can't really, read the tea leaves there to see what the board is going to do. But I think that the board attempts to do everything within its power to decide the issue before the execution date on August 8th.
Okay. So let's talk about the case in general. I think a lot of people may not be too familiar with it, not that they want to be, because the details, when you start getting into it, are extremely gruesome. The murder was, in fact, extremely brutal. But what is it that it's a stabbing case and a sexual assault case, but what was it that the state argued originally that brought it to the level of a capital case of execution?
Really, it's the aggravating factors that surround this crime. Death penalty is really reserved for the most egregious of murders in Utah, and this case was truly one of them. And the state decided to treat this as a capital crime based on the aggravating circumstances. The sentencing court agreed with that analysis. The aggravating factors found by the sentencing court were, one, that Honie murdered Claudia Benn while engaged in object rape, aggravated sexual assault on the attempted forcible sodomy, and aggravated burglary. Second, Honie's criminal history, principally his attack on his girlfriend Carol a few years earlier. 3, that he committed the murder while children were present. 4, the loss to the community that Claudia Benn's death held, and 4, that he committed aggravated sexual abuse of a child during the commission of the crime. So with those aggravating circumstances, the state pursued the death penalty, and the sentencing court agreed that those factors outweighed the mitigating factors that Honie presented at sentencing beyond a reasonable doubt. And that's why we're here today.
Okay, so the impacts of his crimes, plural, have been really, really significant for Claudia Benn's family. How is her daughter and the children? How are they doing today? And are they standing behind the state's efforts to continue with his death sentence?
Well, it's an interesting question. We did receive victim impact statements. They were anonymously submitted to us, and therefore anonymously submitted to the Board of Pardons. One of them was from Claudia's daughter, again wanting to remain anonymous, and 2 of them were from Claudia's grandchildren, again who wanted to remain anonymous. And it's not clear what the granddaughter's position is on the death penalty, but at least the daughter's victim impact statement seems to suggest that she would like to see the execution carried out.
It could be painful for victims to relive the crime, and the execution can potentially create another reopen the wounds in this case emotionally. Do you find that to be true? I mean, I know that you're an attorney and you deal with the legal questions, but we're all people here, and we do sort of feel these issues, as well.
Yeah, and it's certainly something that we take into account as prosecutors, how these cases impact the victims and the victims' families. Is certainly something that we want to respect, and we want to respect the family's anonymity and desire to remain anonymous. And we certainly appreciate this crime's impact on their lives, which is evident from the record and from the statements that we've received. This had rippling effects not only throughout Claudia Benn's family, but also in the Paiute community that Claudia benefited. She was a substance abuse counselor for the Paiute community, and bettered many people's lives as a result of that office, and her loss was felt deeply by the community.
So, as is typical in a case like this, Honie had appealed his case repeatedly over the years. Has the state's answer to his various claims of appeal been the same, or what have they been over the years? What is our answer to, for example, his claim that he was a person who had a very difficult childhood and was abused himself, and those kinds of things? Did he utilize those kinds of reasons as a way to try to reduce his sentence? And what has our answer been as far as the state goes?
Yes, he certainly looked at the mitigation case that he and his trial attorney presented at sentencing in 1999. Most of his challenges have been directed towards his defense attorney's representation. during the 1999 sentencing, criticizing his trial counsel's mitigation case, the experts that trial counsel chose to present at that hearing, and what Honie calls, a lack of evidence that showed perhaps that he should not be held responsible or punished in the way that the state wanted him to be. But all of those challenges have failed because trial counsel conducted a constitutionally adequate mitigation case, and every court to review the question of the constitutionality of that mitigation case have upheld it. So it's really not been a winning a winning claim for Honie. He's also challenged his choice to have a judge sentence him instead of a jury. He waived the sentencing jury before the jury determined whether he was guilty or not, and he's claimed over the years that waiver was not knowing and voluntary. That claim was most recently brought before the United States Supreme Court, where he argued that his trial counsel was ineffective for not allowing him to make an informed decision as to the jury waiver. The Supreme Court denied review of that claim.
Okay. All right, so where do we go from here? We're in late June of 2024. If anyone's listening to this, it might potentially be dated if things change. But as it stands right now, what kind of timeline are we looking at as far as hearing back from pardons and parole, and then moving forward? The execution date still set for August 8th, right?
That's correct, and we're planning for every contingency, of course, but we expect a decision from the board as to whether to hold a hearing or not within the next week or two. It could potentially be 3 weeks, but I imagine that they will act quickly on that particular decision. If they determine not to hold a hearing, then the August 8th execution date will remain in place. If they decide to hold a hearing, then there are some unknowns, obviously. And importantly, Honie does have some litigation pending in the Utah Supreme Court that could affect the August 8th date. We'll have to see how the Utah Supreme Court rules on those issues in the next few weeks.
All right, Daniel Boyer from our Criminal Appeals Divisions, Deputy Solicitor General. Thank you very much for joining us today for insight on the Honie case. We appreciate it, and we'll update as needed as the case progresses. So thank you very much for joining us. This time remotely. This edition of Legally Speaking is a live taping here in Salt Lake City, and Daniel is in another location talking to us online. So Dan, thanks for hooking up with us and giving us insight on this case.
My pleasure, Rich. Thank you.
All right, thank you for joining Legally Speaking, and we'll talk to you next time.